Start up with preliminaries here. Good afternoon, everybody. Thanks for joining us for this exploration of recent records access cases. We're going to talk a little bit about procedure, about the experience that a requester goes through when they appeal from a denial or a partial denial from an agency, and we'll go over some specific cases. This is going to be geared at a general audience. You don't need to have legal or paralegal training, although I know many of you who do. But it'll be hopefully interesting and entertaining for everybody. We'll have some quirky facts and analyses along the way, and I'll explain any technical jargon that comes up. And feel free to chat anytime. If you've got questions, I'll get to them, and I'll stick around at the end for as long as anybody wants to continue the conversation. My name is Nick Weil. I am a trial attorney for the Office of Open Government. You see on this slide our sort of corporate structure. We're under the Board of Ethics and Government Accountability. And I'm going to go back in the slides here. We're going to start with a little bit of procedure. Why I called this seminar Recent Records Access Cases. I didn't call it FOIA cases because we're going to get into some cases from other jurisdictions too, and not every state uses the term Freedom of Information Act or Freedom of Information Law. Some do, but there are a couple of different terms that they use. There's the Right to Know Act in some jurisdictions. You've got a Government Access Act. And in a later slide, I'm going to give you a kind of a search string that incorporates all of them, all of the current short titles, so that you can search for yourself if you want to, and do a comprehensive 50 state survey if you ever want to. So anyway, the generic term is, my point is, the generic term is records access cases. That's what I'm going to refer to them as. We're going to start with a little bit of the procedure as how it goes down in DC. When a requester in the District of Columbia is unsuccessful or not completely successful, that is, they're denied or partially denied their FOIA request, they can initiate an appeal, and they generally have two different branches, literally the executive branch or the judicial branch they can go through. So let's just start by talking about the appellate tribunals. They're called tribunals, meaning either a courtroom or an executive branch agency that acts as a courtroom sometimes. And there are a lot of those. The DMV, you might be familiar with, acting as sort of a courtroom. And in DC, we've got the MOLC, the Mayor's Office of Legal Counsel, that spends a lot of its time acting as a courtroom for executive branch appeals from FOIA denials. And so the requesters have that option. It's cheaper than court generally. There's Superior Court has a $120 filing fee. It's more complicated procedure. The MOLC people tend to represent themselves. It's a lot simpler. There isn't, when you file a petition there, you don't, well, it's not filing. First of all, you just email the petition to them or send it through the mail. When I say you, I mean the requester. And there's no font size you have to adhere to. You don't have to have a cover page with a caption on it. So it's procedurally dialed back. And so understandably, people generally prefer to initiate their through that executive branch tribunal of the MOLC. And so we're going to go over some MOLC cases today, and I'll also show you some ways to find them, because they're sort of stuck in a couple different corners of the internet, and there's a couple of little tricks to staying on top of developing case law that comes out of the MOLC. The other option for taking a FOIA appeal is the judicial branch, to go into superior court. And in fact, if you've been denied a record in the possession of the Attorney General or the counsel, you have to, I keep saying you, the requester. I realize my audience here is agency folks, but I'm kind of presenting to you, hopefully, the experience that the requester goes through, a little bit of the experience from the requester side, so that you'll be armed to either help defend the agency or have some better understanding of the overall experience and the case law that comes out. Anyway, so the requester's experience of going to superior court, like I said, $120 filing fee. It at least in theory takes longer. There can be the court system's own standard is 2 years from filing the complaint to disposition of this type of case. So it can take a lot of extra time. Unlike criminal cases, there's no right to a speedy trial. There's no right to appointed counsel. There is in superior court a great mediation system. There's a free mediation program called Multi-Door that either the judge can refer the requester, refer the parties to. It doesn't just apply to FOIA cases. It applies to any civil case. Either the judge can refer the parties to mediation, they can ask for it. It's wonderful, and it's confidential. If the court mediator, the court employee who mediates the case, the court volunteer who mediates the case, it's a panel of volunteers from the public. They don't become witnesses in the case. It's a confidential process. So it's a small plug for the Multi-Door alternative dispute resolution program. That's a great way to divert cases out of that would otherwise have to go through the whole process in litigation. So let's see, what am I doing here? Either way, either of these routes, whether the requester goes through the judicial branch, the executive branch, they have to follow procedure, follow the rules. You don't get a break if you're self-represented, or if you're not a lawyer. You still have to follow the procedures. And like I said, in the MOLC, they're relatively spare. Actually, the procedures that I should make you aware of as an agency representative, two of the most important deadlines are 5 business days and 10 business days. So once if the agency denies or partly denies the request, the requester appeals to the MOLC, and then at the same time they're supposed to send that petition, the appellate complaint, as it were, to the agency. And the agency is supposed to respond to the MOLC within 5 business days, a very short deadline. You got a week. You got a week to present your side of the story to the MOLC, to explain, here's why we exercise this exemption. Here's why these records don't exist. Here's why the request was unreasonable to process in the first place, because it was framed as a question. It was framed as us performing legal research for them. The record simply, whatever your side of the story is, you've got a week to present that to the MOLC. And the MOLC, and you are allowed to ask for an extension, but the MOLC has to respond statutorily within 2 weeks, within 10 business days is the mayor's office of legal counsel's deadline for disposing of the petition, and that is short. And the office, the director of open government, my office is on record as saying as observing that that's a short deadline. And so but I'm here to report to you the current state of the law. And the current state of the law is that they have 10 business days to dispose of the petition. So what happens if they don't, as has recently been the case? That is considered constructive denial. That's regarded as administrative exhaustion. Exhaustion is the judicial principle where, in order to sue, so step back. Generally, an executive branch agency, if it makes a decision about an individual party, let's say a quasi-judicial decision, the kind of decision that you can then appeal into the court system, that the party, there's generally a doctrine of exhaustion. You have to have taken the administrative remedies as far as you can before you go into the court system. If you appeal prematurely, it's just like taking a parking ticket straight up to the U.S. Supreme Court. I mean, there are a couple of procedural problems with that, but one of them is that you will not have administratively exhausted your remedies. You have to go through the agency as far as you can. But if the agency is silent, if the agency doesn't respond to you, in this case after 10 business days, then that's considered administrative exhaustion, and the requester can go straight to superior court and sort of take it up to that next level if they want. And this is okay. And while we're on the subject of tribunals, I want to ask one more question. We're gonna get into some specific. We're going to get into, well, I'm going to show you how to find some of these cases, and then we'll talk about some specific ones. But one last procedural question. Let me rest your mind on this. Can a requester sue in U.S. district court? Do they have to go to DC, local DC court, or can you sue an agency under DC FOIA in U.S. district court? Can they go to federal court? And DC is a little bit complicated, so maybe think of this in terms of somewhere else. If someone is in Idaho, can they go to federal court in Idaho and sue an Idaho agency for a violation of Idaho's equivalent of FOIA? Think about what your answer to that might be, and we'll come back to it in one of our cases. So let's talk about finding the law. And this is one more thing let me say about this before we move on, in case we don't come back to it later. There is a criminal, we've been talking about civil procedure here. There is a criminal provision in FOIA about a violation of FOIA. If there's a, quote, arbitrary or capricious violation of FOIA, the agency can, well, the actor who committed that violation can be fined up to $100, and it's a misdemeanor. This hasn't been exercised in the District of Columbia, but it has been exercised, and a conviction has resulted, and a member of the school board in Florida did 7 days in jail for a FOIA crime down there. We might get back to this later, but that was an interesting case. I went in search of that last month. But my point to this is, even though FOIA crimes in DC are sort of a quaint provision that's not used in history so far, the bigger threat, you could argue, than that $100 is the fee shifting. So if a requester prevails against the agency in court, if the requester goes to court and wins, even in part, that entitles the court to award attorney's fees and costs. And as you know, that can be sizable. There was a recent FOIA case in which the demand for fees was $400,000. The court seemed a little skeptical $400,000, but it it can get a lot higher than $100. Let's put it that way. Even so, proceed proceed with an attitude of openness and transparency, and hopefully that's where it ends for you as far as punitive consequences. So let's go on to finding these appellate decisions. I promised you a search string for the different states' freedom of information laws. I'll come back to that in a second, but let's talk about finding MOLC opinions. It isn't always easy. They're published in the DC Register, and some of them are many of them are posted online as well. You can find them at dc.gov. You can search for them. Some of the more recent ones are not there. So if I can kind of summarize this all, the most comprehensive way to search for MOLC opinions, and also bear in mind the MOLC was only the appellate tribunal, the executive branch tribunal, since I think 2015. So before that, it went back and forth between there was the secretary's office, there were an acting secretary or two, there was a mayor's general count. The different names and different offices sort of took on this role as the mayor's designee to resolve FOIA appeals. So it's not even necessarily just MOLC you're looking for, but so it gets complicated. But the most comprehensive way to find these non-judicial opinions is to search the register. And if you're lucky enough to have Lexis or Westlaw, I have the search strings here. This is an example I've set up if you're looking for opinions about an exemption. Not all, as you know, exemptions aren't the only way that a FOIA request can be denied. It can be denied because we didn't have the records, for example. But this is a sample of how to set that up. If you're looking for MOLC opinions that are older than 1998, which is as far back as Lexis goes, unfortunately or fortunately, hey, I always say I love jobs where I've had to literally crawl around in the stacks of libraries to find things, and I'm kind of an old soul for law libraries in that way. But so whether you regard it as fortunate or unfortunate, the Washingtoniana collection on the fourth floor of the Central Library, the MLK Library, is a neat collection, and they have the register issues all the way back there, and they have indexes at the end of each year where you can search for Freedom of Information Act appeals, FOIA appeals. They don't use consistent terms necessarily to capture these, but that's, for better or worse, that's how you do it. It can take some literal crawling around the library. It can take some digging, but I've provided you some different sites and some different strings here, search strings, so you can come back to that. And if you're searching over Lexis or Westlaw, let's say, for the state statutes, for the legislative enactments, then this is something that I've read. I've done this job for a few years now, and I was lucky to find this in a treatise recently, because I would if I would look for states case law, I knew, well, some of them use the term freedom of information. I knew about sunshine. I'm from Missouri, and they have the Sunshine Act there, and I knew about the public information law, but I wanted a comprehensive list of all of them that all the states use. So this string here includes all of the short titles for all the states and all the territories and the District of Columbia. So if you're interested in any type of 50-state survey, 50 states plus territories plus the District of Columbia, that string will work for you. Okay, now hopefully the fun part. Let's get into some specific cases that we're going to talk about. And this one, it's even by a little bit of coincidence, we're going to compare a Molk opinion to a Superior Court opinion. They're similar, but I don't know they're necessarily in conflict with each other, and I'm not making that argument. We'll learn something from both of them, and the point at the end of this will be you can learn from both. You can learn from both Molk opinions and judicial opinions, and I say opinion. Actually, the Superior Court, it's not an opinion; it's an order that it hasn't been. It's not a published opinion per se, but if you want to search for an unpublished order, that's a whole other animal, because the Superior Court now has a new portal that's free. You can access trial level documents for free, but it does take a little bit of getting used to. But anyway, I've done the work for you here, and I've broken out the opinion. I've broken out the documents into the relevant relevant components, so we'll be able to learn efficiently from them. Let's get into it. In this case, the Chicago Justice Project case, this case challenges what we might have learned, what we might have thought of, that a FOIA request has to be presented very simply. It can't require the FOIA officer, let's say, to perform legal analysis. It has to be presented simply and reasonably. This request, it was long and legalistic, required the Freedom of Information officer to perform some legal analysis in order to resolve the request. And yet the court, as we'll see, remanded and required the MPD, the Metropolitan Police Department, to follow up and finish searching for records. So this request came from the Chicago Justice Project. They were after the MPD for finding information about the MPD's gang tracking database, a database for keeping track of people who putatively are affiliated with a gang. And they had a whole long list of a couple of dozen requests. This is the ultimate request we're talking about here, that the court made the MPD go back and finish delivering records on. Of this couple of dozen sub questions within this document, this one, number C2, is the only one that the court fully remanded for the MPD to finish. There were other positions on which the MPD won in Superior Court or wasn't challenged, but for C2, they had to go back and finish. And the point I'm making at this, if we imagine ourselves as the Freedom of Information officer and we get this request in, please provide records sufficient to show such and such, who can view or otherwise have access to the data within each database. Database there is capitalized, or records is capitalized, because they're using those as legalistic defined terms. They wanted the FOIA officer to go back and what's a record? Well, a record is a document or an electronically stored such and such writings, including but not limited to, and all these legalistic definitions in order to figure out what's a database. A database is any collection of data, information. It's a really expansive sort of covering the ground, expansive legalistic record request that the that the Chicago Justice Project presented to the MPD. And the point is, despite how legalistic and boilerplate it is, it was deemed a valid request by the Superior Court. My point is that look at this as a warning shot. The Superior Court is telling future agencies, don't rely on a request being legalistic or posing expansive definitions or requiring us to follow a long list of boilerplate instructions as an escape hatch. The MPD should have at least shown the Superior Court that it carried out the relevant search for this was the holding of the Superior Court. I'll read to you the language from the Superior Court's order. As written and viewed in light of its plain meaning and accompanying definitions, the requester's request number C2 included emails. Okay, because you got to go back and remember that records include emails. So you got to go back here and so the request number C2 was specific enough to indicate to MPD what records, including electronically stored writing such as emails, it was requesting. Therefore, MPD failed to complete a reasonable search for the records because it did not look for emails. So the Superior Court granted partial summary judgment to the plaintiff and sent the request back to the MPD for completion. Let's compare this to the Rose case. This Rose case here. This is from the Mulk, as you see. It was a simple question, a simple request, but asked in question syntax, and to me that I think this is interesting. I'm not going to try to, and they're tough cases, so I'm not going to try to conclude as to whether there's a conflict between these two. I'm throwing them out to you and letting you make up your own mind on them. But bear in mind that the Superior Court outranks the Mulk. But here's a case that went before the Mulk where it was a simply worded request, but they used a question mark, and it seems like maybe because of the question mark, the MPD denied the request, telling the requester we're not obliged to answer questions or do legal research for you, and the Mulk agreed with them. So this is an interesting one. You see the request here. The head of the such and such a police unit investigating communist activity in that country is said to have contact with the police in Washington, D.C. sometime between 1933 and 1939. Now, granted, that's background. They haven't asked the MPD to perform that legal research. They haven't asked the MPD to confirm or deny that historical fact. They're just giving a little bit of background. The person in the question was Captain so-and-so, a revolutionary from the 30s. Do you have any records of communication with this Brazilian officer? Question mark. And MPD, and to be fair, to be comprehensive, MPD didn't deny the request based on that question mark right away. They did write back first and acknowledge the receipt. And this is where it gets this is where I think the nuance kind of kicks in. That it isn't just a case of the requester used a question mark and therefore lost. The requester made the mistake of writing back to MPD. MPD responded to the requester and said, we can do, well, we acknowledge your request, and here's the fee schedule. if you want us to proceed with doing the record review. And the requester made the mistake of responding, while I'm willing to pay, I do not need more than a simple yes or no plus the date. If Brazilian police captain so-and-so was asked to have some contact with the MPD in 1936 and 1937. So that pushes it past the simple question mark that was asked in the first batch of the request. In the second batch of the request, the requester pushed it a little bit past the line. MPD said, "You're asking us to go on a hunt for you. We're not going to do that." The MOLC, I almost said the Superior Court, the MOLC, acting as the appellate quote court in this case, the quasi judicial tribunal in this case, agreed with MPD that it is not obligated to create records. It is not obligated. I don't see where the record would have been created, but they agreed with MPD that it's not required to perform legal research for the requester. So the bottom line is the requester pushed it a little bit too far, got themselves denied, and the MOLC upheld it. Let's go on to, if there's a lesson to that, it's don't forget about the MOLC. Bear in mind that the Superior Court outranks the MOLC, and do complete research and come to the Office of Open Government if you need help in analyzing these types of questions for you, because they can involve nuance and expertise, as you see. One of the questions we get this question a lot: does DC case law recognize a GLOMAR doctrine? Apologies if you already know what GLOMAR is. GLOMAR was a submarine from the 70s. The U.S. government commission, as it turns out, this has all been declassified at this point. The U.S. government commissioned a submarine to investigate, to search a sunken Soviet submarine, I think, some sort of submerged craft, to find if there were any intelligence goodies on board, any Soviet secrets. A requester, I think it was an independent journalist from, I think, Washington State, wrote to the CIA her FOIA request asking for information about this GLOMAR submarine. And at that time, the existence of the GLOMAR project itself was, I think it was called GLOMAR Explorer or something like that. Somebody can tell me if they know. The GLOMAR Explorer's mere existence itself was classified at that time. And so the CIA, this was kind of the origin of the pop culture term, I can neither confirm nor deny. The federal FOIA statute, and DC FOIA for that matter, but this concerned the federal FOIA statute, doesn't expressly provide for a not confirm or deny response. You either have to, on the plain language of the statute, you either have to cough up records or deny because the records don't exist or they're properly withheld. But in this case, to produce a document and say, here's the floor plan of the GLOMAR, but it's blacked out for you because it's classified. GLOMAR Explorer. Thank you, Anthony. Would still acknowledge the existence of the GLOMAR Explorer in the first place. So the question was in this case, is a GLOMAR response appropriate, even though it arguably is it responsive, is it legally responsive to the federal FOIA, even though it arguably doesn't either produce records or deny or acknowledge the existence of records but withhold them? And the answer was yes, that a GLOMAR response was an acceptable way to respond when the giving a yes or a no would reveal classified information. So the question is, does DC have a GLOMAR doctrine? And if you search Superior Court Court of Appeals opinions, if you search DC case law, you won't find the word Glomar. You won't find a discussion of the Glomar doctrine, but it's in the Mulk. The Mulk has acknowledged on a few occasions the validity of a Glomar response. It's come up a few times when somebody has asked MPD for the status report on a disciplinary action against an officer, and merely acknowledging the existence of a disciplinary action, even if it's completely redacted or withheld, would acknowledge that indeed a disciplinary action was being carried out on such and such a person. And that was, they deemed that, the MPD deemed that, and the Mulk agreed, a clearly unwarranted violation of personal privacy, such as so as to trigger the privacy exemptions. And so I like the way that, let me see what's on, I don't think I have this on okay, yeah, these are, so the opinions that I've cited there are the two that have set this out the best. I know, so the Mulk has said that a Glomar response, quote, is warranted when the confirmation or denial of the existence of responsive records would in and of itself reveal information exempt from disclosure, such as when the requested records would reveal whether or not an employee was investigated for misconduct. So to identify the written records or the absence thereof would likely result in the harm that the DC FOIA privacy exemptions were intended to protect, and no amount of redaction could protect the privacy interests at issue. So the lesson is, don't forget to search the executive branch appellate opinions to interpret DC FOIA, because as I said, if you search judicial case law, you won't find Glomar. Indeed, if you search judicial case law of the 50 states, because I did this, not many states judicial case law have contemplated Glomar. About 15 states have even mentioned it. So let's see, let's go on here. We're got about 22 minutes. Let's go on to some more Mulk opinions. These are the balancing of public interest against privacy interests. As you know, many of my colleague has a seminar on the different exemptions, and of course not all exemptions have equal popularity. The privacy exemptions are invoked a lot, and one of the privacy language, especially like exemption 2, doesn't just say a record can be withheld if it contains personally identifying information. The mere existence of a social security number doesn't authorize the withholding of a record. Maybe the person with the social security number is dead. Maybe the person with the maybe they've been dead for 50 years. Maybe the person with the social security number is asking for the record about themselves, and we'll come back to that in one of these cases. So in the first one here, and these are short. The head notes I've written out there speak for themselves. I'm blocking my screen. Okay, the 238 case, yeah, 2019 238. The Mulk, I almost said the court again. The Mulk affirmed the exercise of exemption 2 of that clearly unwarranted invasion of personal privacy. The Mulk affirmed the exercise of exemption 2 because an adequate public interest was not demonstrated with respect to third-party Uber receipts. The requester didn't demonstrate such a public interest in the identity of an Uber rider that was too far. Being an Uber passenger, at least on these facts, was enough to trigger privacy interest. 236, similar case with respect to the victim statement, a VIS, a victim impact statement in a criminal case. As you may know, in in a lot of pre-sentencing proceedings, a victim in a, let's say, a violent crime can submit a victim impact statement to the court, um, and that victim impact statement, the MOLC has held, is is so intertwined with the privacy interest that that the public interest is that the privacy interest permits the exercise of exemption 2. The last one there, Pearson, the being a successful candidate for a government position, even though at a lower level, applying to a job may involve a privacy interest that you retain. Merely applying for a job with the government doesn't open up your entire world of PII to discovery or to production under FOIA. But if you are a successful candidate, that tends to tip the balance more. And of course, the higher up ranked of an employee you are, the less of a privacy interest you have. So this balancing test is demonstrated by some of these cases. I promised you we would come back to this one. This one was kind of amusing to read. There is no Privacy Act in DC as there is in the federal statutes, Privacy Act of 1974, I think it is, that there's a procedure for a federal agency. If you yourself want records about yourself, you can go through to thank you, colleague Skirbo, for the webinar about the FOIA exemptions there. That you can go through a procedure to get records about yourself more easily than you would getting records about somebody else. DC doesn't have that sort of Privacy Act, but that's not to say that a requester can't request records about themselves. It's just a more case-by-case, almost common sense procedure for resolving it. In this case, the MOLC was scolded the MOLC scolded the Metropolitan Police Department for not going back and verifying the identity of the requester rather than kicking it out. So the requester asked for, quote, all public records from 2006 to 2019, which refer to, reference, remark about, and or comment regarding, I forget his first name, but Mr. Winters, or any aliases with the last 4 digits of his social security number as ... He accurately gave his social security number, born in such and such a place. So he was identifying records between 2016 and 2019. It's a broad period of time, but that's fine. If he's willing to pay for it, that's fine. About this particular guy, born in this place with this social security number, and the guy is me. And he said that, the guy is me. But MPD summarily denied the request, saying that pursuant to Exemption 2, release of responsive records would constitute a clearly unwarranted invasion of privacy. The MOLC remanded for release of the records by MPD, holding that MPD should have gone ahead and processing the request by confirming whether the requester was indeed the person identified in the records, thus negating the privacy interest under which the records were withheld. So that case is another sort of warning shot. The MPD was overly doctrinaire about they saw privacy in the air and panicked, and they got themselves slapped by the MOLC. Let's talk about some court cases. I'm gonna, let's see, in the interest of time, in the interest of time, I want to make sure that I hit, and I want to give you some sort of fun examples at the end. Let me do Gooch real quick here. I asked you earlier, can a requester sue in federal court for a violation of DC FOIA, of the Local Freedom of Information Act of 1976? And the short answer is yes. There is, even though federal jurisdiction is very narrow, you really, in order to get into federal court, you really have to have a basis of federal jurisdiction. But one way to get access to the federal courts is supplemental jurisdiction, it's called, or like pendant jurisdiction. If you can hang on a local claim, or sorry, well, a state claim onto a federal claim, then the federal courts have jurisdiction. Somebody's unmuted. Doesn't mean to be. And so that's what happened here. There was actually a recent case where it got settled out, so the court didn't actually have to hear it on the merits. But a very recent case, the unsuccessful requester went to the U.S. District Court in D.C. and sued on the basis of a 14th Amendment violation, saying that basically this depriving me, going out of their way to target me for bad treatment with respect to my FOIA request violates my 14th Amendment due process, equal protection rights. And by the way, I'm going to also hang on a local DC FOIA claim. And the case ended up settling. But in the Gooch case, Gooch is an inmate and is attacking his sentence collaterally, like a habeas case. In other words, if you're sentenced to prison, you can still indefinitely attack your sentence as being illegal if, say, new evidence comes up, or the criminal. Sorry, somebody. I can't figure. I don't want to call someone's. Oh, okay. We can just mute. There we go. We'll mute. There we go. So you can attack your sentence, that your sentence is illegal because the criminal court in your state illegally sentenced you, and that's what Mr. Gooch was trying to do. So in order to prepare for that habeas case, he was trying to get records from the Metro Police Department. He got denied, and he sued in U.S. District Court. But that was his only claim. He didn't use that federal jurisdictional hook. He just went to the wrong court, and the district court, U.S. District Court, literally said, "You're in the wrong court," and dismissed. And the court can dismiss sua sponte, on its own initiative, even all the way up on appeal. It is never too late for a court to realize that it doesn't have subject matter jurisdiction and throw the case out. It doesn't have to be moved by a party. The court, on its own initiative, even all the way up through appeal, can say, nope, we never should have had anything to do with the subject matter. So in this case, the district court, on its own initiative, threw the case out because Mr. Gooch went to the wrong court. He came back to, he figured out that he needs to sue in DC Superior Court, which is what he's done, and the case is now pending there. Let's go on to, let's check the time here. Okay, good. And like I said, I'll stick around afterwards for questions, but I'm gonna, in the interest of time, I'm going to pick my favorite here to start with. The last one, the presidential electors case. This is in Texas. Now, why are we talking about, how can we learn from a Texas case? And I'll jump ahead of myself. The Texas statute is different than the DC statute. So how can we learn from a different statute from a different state? Well, we can learn by contrast, just as we can learn by comparison. In this case, the Texas open records statute, whatever it's called, I forget. It's called the Public Records chapter of the Texas Code. Defines a public record as, documents, or information associated with a, quote, governmental body. And so at issue in this case, in the Lamb case, is, are presidential electors a governmental body? So if you're if you're a presidential elector, meaning the slate of mostly ceremonial handful of people who actually vote for the president from a particular state, those people are elected in November on election day. They are sent by their political party to usually the state capitol. They get together as the electoral college for that particular state, and they cast their vote. They're the actual votes for president. The question before the Texas Court of Appeals, this it was are those presidential electors a governmental body? They only exist for about a month or so between election day and the time they cast their vote, but are they a governmental body in the meantime? And the court, as you see here, said no. The holding, I'm going to quote here: Texas presidential electors are not a part of any state governmental body. They are members of their respective political parties. In 2016, they were members of the Texas Republican Party. The Texas Republican Party does not fall under any of the definitions of, quote, governmental body found in Texas's public information law. And therefore, the presidential electors are, quote, members of the public for purposes of the public information law. That the electors may go to the state capitol to perform their singular function, and that they might get travel expenses in a manner that a state employee gets paid such expenses, does not bring their role within a state governmental body. So that was an interesting one. Let's see, where are we? This is the criminal case I was talking about, State versus Webb. There's an article on that you can read. I won't spend more time on it now, but the respondent in that case did 7 days in jail. It was actually sentenced to more. Some of it was suspended, but did 7 actual days and nights in jail for violating the public record statute. Let me talk about the mailbox rule cases. If you look at the numbers 3 and 4 there, McCarley and Eddington. In the McCarley case, the state statute in Ohio, again, this is one that's different from DC, but we can learn from those just as well. The state statute in Ohio provided for damages for a violation, not just attorney's fees, but if a successful plaintiff who's denied a record can recover damages as you would in a personal injury tort case. But the plaintiff would have needed to send the request, and someone's driving down my street on the left side of the road. I hope they correct that. But they would have needed to send the request by a trackable method. In this case, they used the plain old first class mail, put a stamp on it, mailed it, didn't get a tracking number. And the statute explicitly says, I went in and looked at it, the statute explicitly says, I don't know if I have it, but that you had to send the request by by certified or registered mail, and they didn't do that. So the court understandably, very literally applied the plain language of the statute and said, sorry, Charlie, sorry, McCarley, you don't recover damages because you didn't use a trackable method. Now contrast that, and so that was in a way that reflects a bit of a lack of faith in the Postal Service. Contrast that with the case below that, which I think is so quaint, so interesting, from the U.S. District Court in D.C. This is related to the federal FOIA statute in D.C. It's from a federal court in D.C., but applying the federal statute. But it considers the reliability of the Postal Service, and the court here loves the Postal Service, and the requester had used email to send his FOIA request, and he produced an exhibit in his motion for summary judgment. I think look, here's the timestamp from when I sent the original email. Here's and I'm swearing out an affidavit that this is a legitimate, undoctored representation, evidence of when I sent this email, when I sent this request. The court said, oh, and then the reason why this mattered is because when the date and time at which he sent the request started the response clock for purposes of when the agency would have been overdue. Um, if you're familiar with contract law and you're familiar with the mailbox rule is this old common law doctrine where if person A makes an offer to person B and says, I'll buy your I'll buy your pair of sunglasses for $100. This offer expires in 5 days. And day two, person B puts a response in the mail, an acceptance in the mailbox that says, I accept your offer. Here's $100 check. I'll look forward to getting the sunglasses from you next time. Day three, before person A receives the acceptance, calls up B and says, wait, deal's off. These sunglasses it doesn't even have to offer it. The deal's off. Too bad. By putting the letter into the mailbox, person B had already ratified the contract as a matter of common law. But in FOIA, the court tells us they didn't address the question of whether there's a mailbox rule in FOIA, but they did tell us there's definitely no mailbox rule with respect to email. And they go into this charming, fawning adoration of the Postal Service, and it was if only email had the indicia of reliability that the Postal Service provides us, maybe there could be a mailbox rule with respect to FOIA. But unfortunately, all we have is this guy's affidavit that he sent an email. It isn't like he threw his request into the mailbox. He sent an electronic email. So the court, the requester lost on that particular point. I think that's an interesting case. Let's see what we are about out of time. As you can see, the point, if I don't mind running out of time for this because I want to leave you with the correct impression that there's a lot of this, and that there isn't just FOIA case law isn't just limited to 1 hour, that there's a lot of this and could go on and on. I guess I'll give you this couple of slides here is these three judicial cases, one Milk case I've synthesized here for you. This is a good case law standard for responsive adequacy. And the lesson from this is remembering. Let me finish my point though. So we're about out of time. If you have any questions, you can chat them, or I'll stick around. But let me sort of wrap up with this lesson from these 4 cases, that when you're responding to a FOIA request, whether affirmatively or negatively, keep in mind that you might have to defend your decisions in court someday. It's okay. It's not taboo to have that in the back of your mind. If you keep your notes in an organized and consistent fashion, they're more likely to be admissible as such. Be prepared to adequately explain how, not just what you searched for, but why you use particular search terms, why you only use particular search terms, and did you reevaluate along the way during your search to see if maybe some of the records that some of the emails, for example, that you found, maybe open up different routes that you could go down that not just might yield additional records, but are likely to yield additional records. And if so, it's your duty to FOIA to go explore those. It's been a pleasure. And there's interesting and often funny, quirky body of law about this. And I'd like to do a follow-up one of these days. And of course, these are only relatively recent cases. So there's always more coming along. I thank you very much for your attention, and I'll stick around if anybody wants to comment or question anything. But thank you very much for your service to the district, and keep in mind an attitude of openness and transparency. Here are my colleagues and our phone numbers, and reach out to us for advice if you anytime. Coffee.
Thank you.
Thank you, everybody. I appreciate it. Don't feel like you have to stick around. You can have a wonderful afternoon.